All right, hello everyone. During this lecture or this presentation, we're going to talk about kind of the process or steps from the time that somebody is arrested until they are arraigned. So you've been arrested. Now what? Kind of a review. So the first step in this process, right, is making an arrest. So the police make contact and make an arrest. Those arrests could be warrant-based, right? So these are the most formal type. You have the pre-approval through the judge based on probable cause. You might make a warrantless arrest as well. So this is like if you directly observe a crime as the officer, or you establish probable cause to believe that somebody has committed a felony. You don't necessarily have to wait to get a warrant in those cases, but those are kind of those two options for having a legally justified arrest, right? So our probable cause standard is more than reasonable suspicion, but less than proof beyond a reasonable doubt. And again, just a reminder that the officer needs to be informing the arrestee of their Miranda rights or protections if they are under arrest and are going to be interrogated. So if you're just being placed under arrest but you're not planning on they're not planning on interrogating you immediately, they don't necessarily have to Mirandize you in that moment. They might wait until they get you to the station and decide, like if you're going to be questioned, things like that. So some kind of key points to remember: making an arrest or someone being under arrest is considered a seizure under the Fourth Amendment. So you do have all those constitutional protections that are applying there. Any Miranda violations don't necessarily invalidate the arrest itself. So like if you aren't Mirandized after your arrest and they do interrogate you, it doesn't mean the arrest is invalid, but it may lead to the exclusion of certain statements when taken to trial. So they might not be able to use some of the information that you said or admitted to if you were not properly Mirandized. So after you've been arrested, we go through kind of the booking and processing procedure. So first, they're going to ask for your identifying information, right? So they're creating this official arrest record with a unique booking number. It includes any of your aliases, your known associates, and emergency contacts, as well as immigration status kind of being checked potentially depending on the jurisdiction that you're arrested in. They'll also take this time to fingerprint the person and take photographs of them. So they'll do digital fingerprints, which are uploaded or entered into AFIS, which is the Automated Fingerprint Identification System. They'll do a background check to determine if there are any outstanding warrants for the person that's been placed in custody, or if they have any prior arrests. They take photos at booking, and those become a part of this person's permanent record. At this time, officers will then work on their incident report. So they're going to do a detailed narrative of arrest circumstances. They will also document and establish the chain of custody for any of the evidence that they've collected during the arrest, and record and document any witness information and statements made by witnesses or potentially victims. So there are some timeline requirements around all of this. So once you've been taken into police custody, they have to book you into like a jail or a holding facility without any unreasonable delays. So like they need to get a move on. They can't just drive you around town without taking you and booking you officially. At this time, the clock starts ticking towards our mandatory first appearance. So as soon as you're booked, you then have kind of this anywhere between 24 and 72-hour period that they need to schedule your first appearance in front of the judge. And if there are any like unnecessary delays, that could potentially result in your release or suppression of certain evidence even. So people may be placed into different detention facilities. So the classification of the facility or where you're going to be placed is based on the severity of the charge, any prior records that you might have, or safety concerns potentially. Juveniles do have to be separated from adults, and oftentimes there is special housing provided for vulnerable populations, such as folks who are elderly or disabled or experiencing like mental health crises. Typically, our arrestees are offered or allowed 2 to 3 phone calls within a reasonable time after being booked into their detention facility. Calls to attorneys are privileged and they cannot be monitored, while other calls may be monitored by the jail staff, but they cannot monitor any calls that you're making to your attorney. And then if you are an international defendant or you know someone who is an international defendant, they do have the right to contact the consulate for assistance or representation. At the time, after they've been booked and they're kind of moving into their detention facility, they will undergo a health and safety kind of medical screening to identify any mental or immediate health needs. If someone displays any behaviors or kind of risk factors for suicidal ideation or tendencies, they'll be put on suicide prevention protocols. If someone is on medications that they take like daily or anything like that, they would be offered or should be continuing to provide the medication to that person while they are detained. So after you've been arrested, you've been booked, there has to be a probable cause determination made by our judge saying, yes, for sure, this is a valid arrest, this is what you're charged with, all that jazz, based on what the prosecutor has brought to me, within 48 hours. Oftentimes, this is shorter, like it happens a lot faster, but it just depends on the schedules of the courts. For example, like if it's a weekend or a holiday, especially holiday weekends, that might extend that detention period prior to an actual probable cause determination for the arrest. So steps kind of like 4, 5, and 6 are all happening around the same time-ish. So you have our bail assessment. So the judge is going to be reviewing all of the information about the offense, the arrestee, all of that, to determine whether or not this person should be offered the opportunity to be out of jail or out of detention before trial, so as they await their trial. So some of the things that are considered when they're making this decision is whether or not the person is a flight risk. So they look at the person's community ties, their employment status, their family connections, and whether or not they've ever had any past failures to appear in court for other cases. So if they're like really tied to their community, if they're employed, if they have family nearby, they're probably less likely to just like bounce, right? So less of a flight risk. On the other hand, if you have like no ties and no, you're unemployed or like kind of going from job to job, whatever it is, and maybe you've had cases in the past where you didn't show up for your court hearings during the process, then those are all things that they will say, ooh, maybe we don't let you out this time, right? They also consider public safety, right? So they don't want to let someone out who could potentially harm others while they are out on pretrial release. Some of the things that affect, like, especially monetary bail is like the strength of the evidence. So if you have a really strong case against somebody, and especially if it's like a particularly egregious crime, you have a very strong case against them, the judge may then offer them bail but set it at a very high amount, which makes it less likely that they will be able to post the bail and get out, right? All of that being said, bail should not be excessive relative to one's ability to pay. So something that is discussed a lot in the pretrial release literature and research is whether pretrial detention is really just a tax, especially on poor people in particular, or people with less resources. Because I don't know about you, but if I were arrested and my bail was set to, you know, $40,000, you have to come up with 10% to get a bail bondsman to pay the rest. So you're looking at $4,000, and I don't have that just sitting around, right? Like, if it's just some petty little crime, you shouldn't just set somebody's bail extremely high to prove a point. It should be a function of kind of all those factors working together, right? Like, I'm not going to make it so high that you can't pay it. I just want it to be high enough that you have some incentive to come back, is really what it is because if you pay your bail, if you bail out, and you show up to all of your hearings, your bail money is minus fees is returned back to you at the end of it, right? If I bail out and then I disappear, but then I get picked up later for something else, or if I just disappear regardless, like, I don't get that money back. Okay, so it does work as kind of this incentive to, one, you can get out, and it's like collateral, right? Saying, yeah, I will be back because I want to get my money back. But it shouldn't be so extreme that nobody can make it. So when it comes to setting the amount that the bail is going to be, some places use things like bail schedules, which kind of provide starting points, but ultimately judges do have a lot of discretion in how much they set any amount of bail for. It can range from release on recognizance, which is just like you get it. You don't have to pay anything. It's I pinky promise to come back, and they take you at your word because they have no reason to believe you won't come back, right? Like, you aren't at risk of fleeing, you aren't at risk of reoffending, so they feel comfortable saying, okay, we'll take you at your word. All the way to no bail is offered at all, you're not getting out, you don't even have the option, right? So that would be more common in like a capital case, or like a really heinous case. There are some conditions that could be applied if you are released pretrial. So they may require you to wear like an ankle monitor with GPS monitoring. They may require you to engage in drug testing or adhere to like no contact orders. So they're saying, yeah, you can get out, but you have to abide by these rules, and if you break them, you will go back to jail until your trial. So some of the kind of recent developments, a lot of jurisdictions are moving toward risk assessment tools rather than cash bail exclusively. There's been kind of a push and emphasis on least restrictive conditions necessary to make sure that people both appear for their court hearings and don't reoffend while they are out pre-trial. And there's been, that kind of overwhelming recognition that cash bail in particular can create this like wealth-based detention where you have people with less wealth who are being detained more often for the same types of crimes as people who have more money. So like the people with more money are able to get out, but otherwise their cases are virtually the same, which is an unfair and unjust system. So kind of at the same time, you're going to be assigned a public defender if you can't afford one. About 80% of defendants qualify for appointed counsel, and assignment is based on the indigency I have such a hard time with that word. Indigency standards. There are like caseload challenges, right? Because public defenders oftentimes are managing or are representing several people at once. So they're balancing a lot. So what that means for potential defendants is their initial meetings are going to be very short, possibly, but they are still really critical, right? So at this time, you are immediately afforded that kind of attorney-client privilege. So as soon as your attorney is appointed to you, you have those privileges where like anything you talk to them about, they cannot be called to testify against you based on anything that you talk to them about. They tend to focus on kind of the immediate issues at hand during that first meeting. So they're going to talk to you about bail and bail options, and what your first appearance in court will be like. They're going to explain your charges in plain language and explain to you any maximum penalties associated with those charges. And they might talk to you kind of where you're feeling, what you're feeling in terms of the initial plea, right? So are you going to plead not guilty or guilty at arraignment? Most of the times people are going to plead not guilty, and then potentially work on a plea deal or go to trial. So ultimately, kind of the last big thing is making sure that your rights are protected. So they're going to probably advise you to invoke the right to remain silent. They're going to coordinate with your family or friends to help with bail assistance. They're going to provide some initial case assessment and identify any potential defenses that could be used for your case, and start kind of prepping for the arraignment and explanation of the process, right? So after all of this, you're going to then have your first appearance. So this, in most state jurisdictions, your first appearance is going to occur in that 24 to 48 hours after being booked and all of that. Some allow for 72 hours if it's all happens on a weekend. And we have seen kind of this increase in use of video appearances, especially in rural areas. So using things like Zoom calls for your first appearance. And they do have to offer interpreter services if you need them. So at the time of your first appearance, you will be notified of the charge. So you're going to be read the complaint or information. It might not yet be a full indictment against you, but you will be read what it is the prosecutor intends to bring against you. They will explain once again the penalties in language that you understand. They will kind of make the distinction between maximum penalties and what your likely outcomes are, depending on whether you go to trial or not. They'll identify any enhancing factors that are present, so prior convictions or whether or not you used a weapon during the commission of the crime, right? Things like that. You'll be advised of your rights at your first appearance, so they'll tell you, once again, you have your right to counsel, you have the right to remain silent, you have the right to a speedy trial and an explanation of timelines, you have the right to a jury trial for any offenses carrying more than 6 months of imprisonment. So that's kind of the big things that are happening at your first appearance. You're not, especially if it's a felony case, not necessarily going to make your plea at this point. This is not always an arraignment. That's different. So your first appearance is just, here's everything you need to know, right? And then you do your formal arraignment process. So in some misdemeanor cases, they combine them together. But oftentimes it's two separate kind of appearances in front of the court, two separate hearings. So at your first appearance, you are kind of met with your charge, and then at the arraignment, you're going to formally respond to the charges, right? So you're going to that's creating this official record of defendant, your position on the charges. It also triggers any speedy trial timelines in most jurisdictions. This could take weeks after an arrest if a grand jury indictment is required. So in some cases, the prosecutor can just bring the charges against you. In others, they have to get a grand jury together, present all of their evidence to the grand jury, and the grand jury it's just of people around the area who serve on the grand jury, regular civilians. They determine whether or not the evidence presented to them is sufficient for bringing the charges against you that the prosecutor is proposing, essentially. So it takes time if the thing requires an indictment. So you might be waiting. Otherwise, it's a little bit faster. So each count is read separately with specific statute citations. The penalties are explained, including minimum mandatory sentences. Any enhancement allegations are outlined, and the defendant must acknowledge that they understand the charges that are being brought against them. At this point, they can enter into a few different plea options. So you can plead guilty, which is an immediate admission, and this also means that you're waiving some of your kind of constitutional protections or rights. Oftentimes, then also prevents you from being able to appeal anything. You can plead not guilty, which is the standard plea, and it preserves all of your rights and defenses. So if you plead not guilty, then all of those rights that are afforded to you in the Constitution, such as a trial by jury and all of that remains intact. You can also plead no contest in some jurisdictions. So this is when you don't say you're guilty, you don't plead guilty, you don't admit guilt, but you are not denying it or fighting the charges. Then we kind of move on to, after you've entered your plea, the scheduling of future proceedings. So we have the discovery deadlines and motions schedules, a preliminary hearing, a trial date that's set, and plea negotiation conferences that are scheduled. So after we've done our arraignment, so you've decided, I'm going to plead not guilty, right? At this point, we enter into the discovery phase. So the prosecution is disclosing any Brady material or exculpatory evidence to the defense. The defense is doing some of its own investigations, so doing like client interviews, witness statements, and expert consultations. They're all reviewing electronic evidence, so body camera footage, cell phone records, DNA analyses are all happening at this point. If the defense finds certain evidence, then they're required to disclose that to the prosecutor. At the preliminary hearing, if we're making kind of the distinction between preliminary hearings and grand juries, at the preliminary hearing, this is a public proceeding where cross-examination is allowed and probable cause is our standard. A grand jury is a secret proceeding. No defense is, like, the defense is not participating, so there's no cross-examination occurring, and the prosecutor just presents evidence only. Okay, so regardless, they're just trying to determine if there is probable cause for the charges being brought. Okay. So should we continue on with this case is ultimately what the decision is between when we're using a preliminary hearing or grand jury. They can waive their preliminary kind of hearings or grand jury hearings to expedite proceedings. So you can say, yeah, like, I'm fine with what the prosecutor has said. I don't want to go through the process of like waiting for these groups to meet and decide whether they can continue charging me, right? Especially if it's looking like, yeah, they're definitely going to get an indictment on this, then like we don't need to waste everybody's time if it's going to be continue as planned no matter what, right? You can just say, okay, I accept your charges. I'm not going to plead guilty to them, but you don't need to take it to a grand jury. Let's just like move along the process of getting me to trial. Then we kind of enter into our pre-trial or our plea bargaining. So 90%, over 90% of cases, all cases resolve in a plea bargain. So at this time, they're doing like charge reduction negotiations. So maybe saying, oh, actually, like, I could charge you with a felony, but instead I'm going to charge you with a misdemeanor. Will you plead guilty to that? They'll make sentence recommendations and like caps on sentences at the being like, well, they don't need to be put away for life. What if we just do 10 years or time served or whatever it is, right? So all of that is kind of being taken into account. Trying to get these cases resolved ultimately is the goal. But they're also at this time taking into account like victims' input and any potential restitution considerations if that is relevant to the case. We also see like pretrial motion filing. So suppression motions are those that challenge illegally obtained evidence. Dismissal motions attack the sufficiency of charges or procedural violations. And discovery motions compel production of evidence. So if I say, I think you have more and I would like you to show it to me, then I can file a motion about that. Or you might file a motion to change the venue. So if the pretrial publicity affects whether or not the person is going to get a pretrial, you might say, or get a fair trial, you might try to get the trial moved to a different jurisdiction where hopefully people don't know as much about it. So just kind of for context, right, and the timeline stuff, if we look at New York City compared to like other rural jurisdictions, there is quite a bit of variation in the city versus like those smaller places, right? So the New York City's higher court volume actually leads to faster processing in many cases. And then in rural areas, they have less frequent court sessions, which could cause delays. We see 120 or more days that category often involves grand jury delays or complex cases, right? So if we're having that long of a delay, it's because we're waiting on a grand jury indictment, or the case is just kind of quite complex. The speedy trial clock does begin ticking at different points. So like at arrest, you have a certain amount of time, right? That few days before you have to get an arraignment. And then after you've been arraigned, you have unnecessary delay before you must produce an indictment, right? Like all of this is to prevent people from just being put in jail and left there to rot before actually ever going to trial or proving that they are guilty of anything. So delays may occur because of the prosecution, the defense, or even just the court. And only the prosecution's delays count against the kind of speedy trial protection. So if the defendant or the defense asks for a kind of a delay, then like that's on them. It doesn't affect or doesn't go and take into account whether, like, it doesn't get taken into account when someone's trying to determine if you had a speedy trial or not. Okay. I think that is really the big highlights for our arrest to arraignment discussion here. So as always, if you have any questions, please let me know. When we reconvene in our next video, we will be discussing like plea negotiations and all of that, jury selection, all that fun stuff.